Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. We're here today to discuss your employment questions, any and all employment questions that you have, anything related to work that you want to discuss with a lawyer. Feel free to put them in the chat. We are going to try to get to as many of your questions as possible today. Don't wait till the end. Put them in now so that you can make sure that I have time to answer all your questions by the end of the show. So feel free to put them up there. In the meantime, before we get started, I wanted to talk quickly about something that I'm seeing more and more people reaching out to me about, especially here in Alberta. What I'm seeing a lot is people who are asking me, Luke, my employer has classified me as an independent contractor. What are my rights as an independent contractor? Very quickly, I just want to mention that what I'm seeing when these people call me is that although they're called, by their employer, they're called an independent contractor, they are not passing what I like to call the duck test. Duck test, we all know it. If it quacks like a duck, walks like a duck, it probably is a duck. All right. So same thing for employees. If you walk like an employee, talk like an employee, you're probably more likely to be an employee than an independent contractor. And employees have a lot of rights when they have a lot of protections. Independent contractors have a lot less rights and a lot less protection. Oftentimes, independent contractors are not entitled to severance, for instance, or EI, or things like that. So when I tell this to people that, yes, although you're called an independent contractor, you look to me a lot more like an employee, that allows these people to access all the rights that employees have. And really, what you have to ask yourself, if you've been termed an independent contractor, there's a lot of factors that we look into to determine whether you're an employee or a contractor. But basically, the question we're trying to answer is always the same. It's, are you running your own business truly, or are you part of someone else's business, right? And if you're part of someone else's business, then you're an employee, frankly. That's all there is to it. If you're running your own business, we all know, what a true independent contractor looks like. That plumber that comes and fixes your toilet, that kitchen specialist that renovates your kitchen. Those are independent contractors. Someone who goes to work for the same employer for year after year, working in their facilities at the desk they assign to them, the employer's telling them what to do, all of that, that's more likely to be an employee than a contractor. And a lot is at stake, for both sides. So that's why if you've running into any trouble getting proper severance and your employer is telling you you're a contractor, don't just take that for granted, right? Talk to us, give us a call. We'll go through, ask you a few questions that'll help us determine whether you are truly an independent contractor. And if you're not, if you're more of an employee, then you have rights, including right to a fair severance. All right. So if you're ever looking to reach out to us, it's very simple. Just visit us at employmentlawyer.ca. You'll have all the information there. Our phone number is there. A way to contact us online is there. So you can reach out to us. We can speak to you and tell you a little bit more about what your rights are. So thank you for listening to that. While we were listening to that, we got a question come in from Sir on YouTube. Sir is asking, can an employer take advantage of an employee's lack of knowledge of the ESA? I didn't get working notice in writing. I was stressed from termination and gave in to the employer's pressure to volunteer. I guess what you're saying, to volunteer to resign or to be laid off. So it depends what you're referring to exactly. So if you volunteered to be laid off, without realizing that your employer might not actually have any type of right to lay you off, that could potentially mean that you've agreed that you've given now your employer the right to lay you off. If that's what I'm understanding from your question, depends how you communicated this. But essentially, if your employer was saying, I have to lay off 5 people. There's 8 of you. Are there any volunteers? Potentially, that could be, if you volunteered, that could be you acknowledging that your employer has the right to lay you off. I would need the full context So you would have to reach out to us to tell me a little bit more, because your question there was a bit truncated about with the volunteering. So I'm not sure I got that right. But generally, if your employer says, well, you're getting a layoff, and you say, well, okay, that doesn't mean that you're accepting the layoff. I mean, you're presented with a fait accompli, as they say, with a decision that's already been made. You not protesting immediately does not mean that you've agreed that the employer has the right to lay you off. All right. So if you've been laid off, your employer's not calling you back, you realize, well, listen, I don't want to go back there. I think I should get my severance. I'm not going to wait on the sideline here ad infinitum while my employer decides what they're going to do with me. Give us a call, because you're right. If it's the first time you've been laid off, if there's nothing in your employment contract that says your employer has the right to lay you off, well, in fact, the reverse is true. Your employer does not have the right to lay you off, and they need your consent to lay you off. All right. And your consent has to be active consent. So, for instance, a letter saying, yes, I consent to the layoff would be active consent. But then coming back from the layoff could also be active consent. If you're laid off for 3 weeks, and then your employer calls you back and you go back to work and you don't say anything about the fact that you were laid off for 3 weeks, what's happened now is now your employer now has a right going forward to lay you off again, because you accepted the fact that your employer had the right to lay you off by going back to work at the end of your layoff when you were recalled. So something to look out for there. We have another question coming in from Rem Style. Rem Style is asking, can an employer stop you from taking a second job if it doesn't impact your working hours? So it kind of depends on your employment contract. Employment contracts might have a clause that say, that you're going to devote your full time and attention to your job, which means that, you're not going to take side jobs potentially, right? Sometimes you have to get your employer's consent to get another part-time job. If there's nothing in the contract that says that, then you can go ahead. What an employer may be and should be concerned with is, are you taking a competing job? Are you, or something like that, a job where you're going to be competing for the same contracts or stuff like that. For instance, say you work in an office and you decide you want to do Uber on the weekends. You're not competing with your office job or anything like that, so it really shouldn't be an issue. If your employer doesn't like it, they may terminate you, but they can do that in any case. But generally, you'd be owed severance in that case. All right. So unless they can show that you're actually actively competing against them, then having a second job should not amount for cost for termination. So go ahead and have a second job, but your employer might, put you to an election. Decide you want that job or this job, because you can't have both. But then if they terminate you, you're going to be owed severance. All right, so keep that in mind. We have another question coming in from JB. JB is asking, I've heard in other sessions that an employment contract can decrease the amount of severance you are owed. How would you know if your employment contract does this? All right, so it's very common, you're right, JB, in written employment contracts, that they nowadays have a clause called the termination clause. And so essentially what the purpose of that termination clause is to limit how much severance you're owed. So just to get an idea of how much severance you might be owed, you can visit our severance pay calculator. I love this site. It's called severancepaycalculator.ca. You can also access it through our pocketemploymentlawyer.ca. You have that website on the screen. So all you have to do is answer 4 easy questions, no obligation, and we'll give you an estimate of what we think your severance entitlements might be. Okay, just so you have an idea of how much we're talking about, because it can be up to 2 years of severance, 2 years of your full compensation. It can be a lot of money, right? And potentially, if you've been somewhere where you'd be entitled to 2 years of compensation, what the termination clause is trying to do is to limit your severance entitlements to maybe as little as 8 weeks, 2 months of severance. So a big difference there. So definitely these termination clauses can seriously limit your rights. And generally, the way I've seen them structured is they go through scenarios. In the event that you resign, you're required, for instance, to give 2 weeks notice. In the event that we terminate you for cause, you won't receive any severance. And in the event that we terminate you without cause, then this is how much severance you're going to get. And this is all you'll get, and you won't get anything more, okay? And so that's, if you see some language to that effect, and that's your termination clause. That's the clause that's trying to limit your termination entitlements in your employment contract. So be very careful with those, because they can seriously impact you when you're at your most vulnerable, when you've just lost your job. So that's what you're looking for. Those kinds of clauses, they usually start with, might be called termination or something like that as the header, and then have those paragraphs addressing what happens in the event of a resignation, and in the event of a for-cause termination, and the event of a without-cause termination. So that's what you're looking for, JB. All right. And if you want to have us review your contract to get an opinion of what we think of it, what can be improved, whether you should accept this, feel free to reach out to us. We do contract reviews all the time. And we're at employmentlawyer.ca. So you see that on the screen. Feel free to reach out anytime. We have another question coming in from Facebook from Sunny Days. Sunny Days is asking, last year I was on sick leave for a few months. During those months, all employees receive wage increases. I did not. Should I have received an increase? That's a very interesting fact scenario. So I would tell you, if you were, if you had taken a sabbatical, probably not. But now, because you were on sick leave, I'll call it, for the purpose of this discussion, I'll call it a disability leave. And basically, the reason might be that if the reason that you didn't get the raise is because you were on a disability leave, then that can be a form of human rights discrimination. So you shouldn't receive any adverse treatment for the fact that you have a protected ground under human rights. And we all know what those are, or at least most of them for most people, your age, your race, your gender, disability, your religion, things like that, right? So you can't receive any adverse treatment based on your disability. And so if the reason you didn't get the raise is because you were on a disability leave, then that's starting to look to me a lot like adverse treatment, okay? So the first thing to do is to address it with your employer, to say, well, listen, I don't think it's fair that I don't get a raise when everyone else did just because I'm on disability leave. Sounds a lot like discrimination to me. And see what they say. And if they do raise your wage, and there you go, and it should be retroactive to the day you came back, not to the day that it was raised for everyone, because you weren't getting paid anyways, you're on sick leave. The day you came back, you should get retro pay for the wage increase. And if the employer is saying, well, absolutely not, we don't want to do that for you, then you can make a complaint with the Human Rights Commission, and they will look into this as well. Yes. So that's what I would say about that, Sunny Days. I do think you have a claim here. Because there is definitely, in my view, from what you've described, there definitely is a connection between your disability leave, and the fact you didn't get the raise. Absolutely. We have a question coming in from YouTube from Grace. Grace is asking, my employer is selling the business and I am supposed to transfer to a different branch. What will happen to my years of service when I am transferred? All right. So a few things to consider. So, Grace, it might depend a lot on where you are, which province you're in, all right? So I could tell you with confidence in BC and probably Alberta as well, unless your employer flat out says we're not recognizing your years of service, then your years of service will be recognized, okay, just by operation of the law. It's a bit more complicated in Ontario, okay? It gets even more complicated depending how the business was sold in Ontario, okay? But generally, even though your years of service can be recognized for different things, okay? They can be recognized, for instance, with respect to your vacation entitlement, right? But they also play a major role in how much severance you're owed, okay? So Ontario has its own way of dealing with that. But if you're asked to sign a contract from the new employer, then you definitely want to make sure you read it, and definitely want to make sure you see whether they recognize your years of service. And if it's not specified in there and you're in Ontario, then I would address that with your employer and say, listen, What about my years of service? Are you recognizing them, right? They have an obligation to recognize them for certain purposes under the Employment Standards Act of Ontario, but not necessarily for the purpose of your full severance calculation. But definitely, once they put it into your contract, yes, I recognize your years of service starting from your actual first day with the previous employer, then they've been recognized. But at the same time, what you want to watch out for when you get that employment contract is they might recognize your years of service, but as I was telling JB earlier, they might put a termination clause in your severance entitlements, which might limit how much severance you get. So you might have great entitlements currently if you look at our severance pay calculator, but they might try to limit those entitlements to 8 weeks of compensation or less. Even though they recognize your years of service, that might not help you if you're signing a termination clause. So a lot to look at, a lot to consider. So if you're offered a new employment with the new owner and they present you with a written employment contract, this is one where it's especially important that you have it reviewed in my view, all right? Because you have a few different options that you can pursue right now. You could just walk away with severance potentially right now, right? Rather than go work for the new employer. It's definitely something that we should discuss with you. I can't tell you yes or no right now whether you should do that, but that might be something that's on the table if the contract that they're giving you is not too favorable, and they don't tend to be in my experience. So definitely reach out to us, have that contract reviewed. It's well worth the effort. And again, if you're looking to reach us, we're at employmentlawyer.ca. Employmentlawyer.ca, you have it there on the screen. All right, we have another question coming in. Have questions about oh, sorry, that was from us. So yes, so if you have questions about your employment rights, I'll just repeat what we have here in the chat. Post them in the chat so that we can get an answer, and we'll answer live to as many of them as we can. So if you're holding back, don't. We often get a flurry of questions right at the end, and then we're out of time and we can't answer them. So better to get them in now while we still have some time. We have a question coming in here from Gidget. Gidget is asking, hi, I am currently on medical leave after a workplace assault. Wow, okay. Presently, I do not feel safe returning to this employer. Will a constructive discharge work against me in any potential legal action? So if what you're saying is constructive dismissal, if that's what you're referring to, Gidget, then I don't know what other potential legal action you might be thinking of, but you might have a claim for constructive dismissal. So you've been assaulted at work. It's caused you to go on disability leave. I don't have all the details. I don't know who assaulted you and what your employer did about the assault, whether that the aggressor is still around or what's happening there, but you potentially do have a claim for constructive dismissal for your employer not ensuring that you work in a safe workplace, which has resulted, in medical damage, essentially. So I do think that it is possible that you have a constructive dismissal claim. Constructive dismissal claims are very fact dependent. Every one that does constructive dismissal law is going to tell you that. You need to know the facts. So you seem to have some facts that point to that right now, but I need to have a bit more details about who the aggressor was, what your employer did about it, whether you're in any position to return to work somewhere else right now, what your doctor is saying and all of that. So, so my best advice would be reach out to us to give us those details, and we can give you a better idea of what the path forward can be and should be for you, so that so at least you have that peace of mind while you're recovering. I know sometimes it can be very traumatizing, to be on sick leave and to ruminate about going back to this, quite toxic and triggering workplace. Having that squared away can be a big step towards your recovery. So you don't need to let that fester. Reach out to us. We'll be happy to talk to you, give you some ideas of what your options are going forward. So the website again, employmentlawyer.ca. We'll be happy to talk to you about that. We have another question coming in from Frank Cerrone. Frank is asking, after you come back from sick leave, can your employer lay you off? So the answer is yes and no. And no, Frank. The answer depends on whether your sick leave was the reason for the layoff, or part of the reason, or one of the reasons. Okay. Even if your sick leave was only 1% of the reason why they laid you off, then no, they can't. That's discrimination. Okay, that's discrimination under human rights legislation. Okay, so essentially, when you come back from sick leave, you have to be replaced in your job as it was when you left, or if that job no longer exists, then a similar job. Okay, similar in terms of duties, compensation, and title and position. All right. However, imagine a scenario that while you're on sick leave, your department gets transferred overseas, and everyone in your department, so let's call it an accounts receivable department, everyone in your department is permanently laid off or terminated and provided with severance packages. So there's no accounts receivable department for you to return to. So oftentimes what employers will do in that case is not terminate you while you're on sick leave, but rather on the very first day that you return. All right. So in that case, just ask yourself, is the reason that they're terminating me because I took a sick leave, or is it because they've closed the department and there's no job for me to return to? Obviously, if they terminated all your colleagues, then it looks a lot more like it's because they closed the department and there was no one that was kept on. Imagine a scenario where they close down an 8-person department and they're able to move 4 people into the accounts payable department, for instance, and then you come back and then you're terminated. Well, then you have to start asking yourself, well, why did they choose those 4 people and not us other 5? And so basically, if you can show that your disability or the fact that you were on sick leave was part of the reason why you weren't chosen to go into the accounts payable department, then that's discrimination. And you are owed, you on top of the severance you would otherwise be owed, you are potentially owed human rights damages as well. All right. So it kind of, this is where I'm saying yes or no. So yes, it's no, they're not allowed to do that, to lay you off upon your return of sick leave, if one of the reasons for terminating you is that you took a sick leave. But if it's just a coincidence, the sick leave had nothing to do with their decision, then yes, they can do that, so long as they provide you with adequate severance. All right, you're still entitled to severance. You don't lose your right to severance, and your severance will be based on many factors, including your age of service, your length of service. But your length of service should also include the time you were on sick leave. So if you started working there 5 years ago and have been on sick leave for the last 2 years, you're not a 3-year employee, you're a 5-year employee. Keep that in mind, all right? We have another question coming in from Reddit, from IH. I'm a hiring manager and my VP is forcing me to be discriminatory in hiring practices. Am I liable for this if a complaint is lodged against me or the company? What can I do in this situation? All right. So if it's discriminatory hiring practices, and we're talking about discrimination, human rights discrimination, then we sometimes see in human rights litigation where it's not just the company that gets named as a defendant, or in human rights legislation as a respondent, but also individuals within the company, those who are responsible for the discriminatory conduct. So what I would tell you in this case, IH, is what I want to talk to you about today is protecting yourself as an employee, and that's keeping records. If you're executing a strategy that's or a directive that's being passed down from you, from your superiors, then that is you want to have a paper trail of that. All right. I'm dealing with precisely this kind of issue in one of my matters, and the fact that there's paper trails really help out. All right. Secondly, although you may not be someone who has a protected ground under disability legislation, discrimination legislation, and human rights legislation, most human rights statutes provide not only that you can't discriminate against someone for having a protected ground, but you can't retaliate against someone for enforcing their rights or enforcing the rights of somebody else, right? So if you stand up to your VP and say, I cannot, for instance, I cannot refuse to hire this person because she's pregnant, and you suffer repercussions, say that you're fired or demoted or something like that, you now have a claim in human rights, even though you might not be, someone who's pregnant, someone who's, an equity-seeking group generally. You suffered adverse treatment for refusing to violate someone else's human rights. You may have a claim in human rights yourself, all right, for human rights damages, for reinstatement, for lost wages, a whole host of things, if you stand up and do the right thing as well. All right. It's often hard. It's very hard. It's you're basically being asked to implement a directive that is wrong. That's coming from higher up. Your job is potentially on the line if you don't do it right. You at least need to cover your bases. Get this stuff in writing. Keep records of what you're being forced to do here. All right. And know that you'll be protected if you suffer repercussions or retaliation or reprisals for refusing to engage in discriminatory practices. We have another question coming in from Sir. Sir is asking, after termination, they wanted me to stay as a volunteer. All right. So, Sir, I'm just going back to your earlier question here. So you're saying you didn't get working notice in writing. Okay. So there's two ways that under employment standards legislation, there's generally two ways that your employer can provide you with notice, either as working notice, which is to say, I'm telling you today that in 12 months, or let's say the maximum is 24 months, I can tell you today that in 24 months, your job is going to come at an end. From now till the end of that 24 months, I expect you to come in, all right? And during that time, that's your working notice. That's the equivalent of severance, all right? At the end of that 24 months, if all goes as planned, your job ends 2 years from now, and that's the end of it. You walk away. You've had 2 years to prepare for the fact that your job was coming into an end. Now it has ended, and you go on with your life, and that's totally legal. Unfortunately, fortunately or unfortunately, what a lot of employers do these days is they're like, well, I don't want to have someone that's completely unmotivated and knows their job is going to end. They're not going to be, giving their 110%. So what's the point of keeping them around? They might poison the well for my other staff, right? So a lot of employers make the business decision, or they might say, I'm restructuring here. I can't keep someone around for 2 years. I need to do the restructuring today. I can't wait 2 years to do the restructuring. So you'll say, well, instead of us telling you that your job will end in 2 years, here's 2 years worth of salary. Your job ends today, but here's 2 years worth of salary, okay? And that's what we call severance, or it's 2 years of your full compensation. And that's what severance is, all right? So what your question was saying earlier, sir, is you were saying that you weren't given proper working notice, and then you were asked to volunteer. So if you were given severance or termination pay, as it's sometimes called, or pay in lieu of notice, as it's also known, then you may have gotten what you were entitled to. So the question then becomes, did you get enough severance or termination pay or pay in lieu of notice, all right? And if you didn't, it doesn't matter whether you're volunteering or not, you may still be entitled to more. All right. So, sir, I think it's important that you take a look at our severance pay calculator. You can find it on employmentlawyer.ca. On pocketemploymentlawyer.ca. Visit that website. You answer 4 easy questions, and you'll know if you got enough severance or not. And if you didn't get enough severance, then you can contact us right away, and we can help you get the severance you're owed. Okay, so I think the fact that they asked you to volunteer is an interesting kind of biographical detail. Right now, I don't think it's going to affect whether you're entitled to severance or not. So really what you have to figure out first is, did you get enough severance? All right. And if you didn't, get in touch with us. We can help you. And finally, we have time for one last question from JB. JB says, thank you. One more question. What does constructive discharge mean exactly? All right. So in the briefest, the simplest of terms, rather, JB, what I would tell you is that typically a job ends in two ways. Either you're terminated or you resign. We all know this, all right? If you resign, you understand you're not entitled to severance. And if you're terminated, especially on a without cause basis, if you're permanently laid off, you're owed severance, okay? Now, what happens sometimes is that employers do not want to use the words "you're terminated," but by their actions have essentially terminated you, okay? So if they, for instance, if they demote you, if they cut your pay, if they mess around with your schedule too much, if they tolerate a workplace environment that's hostile and toxic, then the tables turn a little bit, and you can quit, which normally people who quit aren't entitled to severance. But in this case, you could say, well, I quit because you forced me to quit, employer. And because you forced me to quit, I am entitled to severance. And I'm going to go after my severance. So if we want to use the legal terms that a court will use, they're going to ask themselves two things. Either did the employer change a substantial aspect of your employment conditions, salary, position, title, work location, job duties, and does that change in your working conditions, which is substantial, does that amount to a repudiation of your employment contract? Does that essentially indicate that the employer is refusing to continue to employ you under the working conditions that you had before? So that's one way that you can establish that you've been constructively dismissed. Another way is there a course of conduct by the employer that shows, over the time that they don't want to employ you anymore, that they're trying to push you out the door, they're trying to force you to resign? If there is that course of conduct, if you can establish that that's what that course of conduct shows, then again, you can resign and go after your severance. In both those cases, you can resign and go after your severance. So, sir, I'm going to thanks for following up there. So you got the minimum severance, so you might be entitled to more, okay? So definitely reach out to us. We can talk to you about, whether you're entitled to more than just the minimum severance under the Employment Standards Act. Most employees are. The vast majority of employees are. The only ones that aren't are the ones that have a valid termination clause in their written employment contract, okay? So even if you have a termination clause in your written employment contract, it may not be valid. That's very important. So you need to reach out to us. We're experts in determining the validity of termination clauses. All of us here. We do it all the time. We're in court all the time, winning cases for employees just as yourself and validating these clauses. So feel free to reach out, set that up, a consultation up with us. We'll tell you how much more you might be entitled to. And Sir is signing off saying thanks. Well, thank you all for joining us today and for your great questions. Always very informative. We've covered a wide range of topics today, and I was super happy to do so. I hope you've learned something today. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. We do employment and disability law. And tomorrow we have my colleague Martin Willems, who's on our live to talk about disability rights, long-term disability, short-term disability, what have you. So feel free to join. We'll be on tomorrow. It's at 10 a.m. Pacific time. Thank you all. Enjoy the rest of your day, and we'll see you soon. Bye now.